Jefferson County Court at Law number 2 is back in session. The court is in session with its trial docket. Court is in session to cause number 23 CCCR 0558, case of style of state of Texas versus Trayvon Darrell Conley. Mr. Conley, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth so help you God? Mr. Conley, you may put your hand down. How are you doing, Mr. Conley? How are you doing? You fine? That's good. And Mr. Conley, you're representing your case by your attorney, Wright Kimler. Attorney Kimler, how are you doing?
Still willing on.
And Mr. Kimler, do you waive a record in Mr. Conley's case?
So waived.
State is representing this case by Mr. Samuel Masradian. Mr. Masradian, how are you doing?
Doing well, Your Honor. Thank you.
And Mr. Conley, I have before me on my computer a document that is titled Information Sheet. This information sheet was filed by the Jefferson County District Attorney's Office. In this information sheet, it alleges that you, Trayvon Darrell Conley, on or about March 12th of 2023, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of evading arrest, detention. Mr. Conley, do you understand what you have been charged with?
Yes, sir.
To this charge, Mr. Conley, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Now, Mr. Conley, are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
Mr. Conley, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there are a set of initials on the line next to a box
Yes, sir.
that's checked guilty. Did you place your initials on this document? On page 3 of the same document, there's a signature above the line that's titled Defendant. Is this your signature?
Yes, sir.
And on the next document that's titled Trial Court Certification, a defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have a document on paper that is titled Discovery Certification. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes,
Mr. Conley, before you sign and initial these documents that I just showed you, did your attorney, Mr. Kimler, go over these documents with you?
yes, sir.
Did you understand everything that Mr. Kimler went over?
Yes.
And is everything in these documents true and correct to the best of your knowledge? Mr. Conley, are you a citizen of the United States?
State offer states one.
No objection.
No objection. State's Exhibit Number 1 will be admitted. Mr. Kimler, you have advised in counsel, Mr. Conley, is there any evidence that he is currently mentally incompetent to stand trial?
No worries.
And Mr. Conley, your attorney, Mr. Kimler has advised in counsel you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Okay, Mr. Conley, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. I also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
20 days in the county jail with credit for the 1 day time served already.
Okay. What's this court cost?
$277.
Yes. That's your card. Well,
I don't know how much that 1 day is going to go to that.
It's $100. Okay, so that's 20 days credit for one. And the court cost is how much? $277?
Yeah.
$277. Okay. So, Mr. Conley, the state is offering that you serve 20 days in Jefferson County Jail. You'll be given credit for the 1 day that you've already served. Court cost in this case is $277. With the 1 day credit, it goes down to $177. Will you be able to pay the $177?
yes, sir.
Oh, Okay, well, I guess we'll give you until,
He's not set to report till
See,
November first.
that's right, that's the, I was gonna, yeah, go ahead. Okay,
He's paying good.
now, it has to be paid at the, county clerk's.
Okay, come here first, and-
Yeah,
or just
Yeah.
sit it out an extra 2 days, I guess.
okay, so, let's see, so you got that 1 day credit, 1 day credit. Let's see,
It's just the way they do it.
177. Okay, 1 day credit. And let's see, that's November 1st, 2025 at 6 p.m. Okay, now, Mr. Conley, the state is offering that you serve 20 days in Jefferson County Jail. You'll be given credit for the 1 day that you've already served. Court cost in this case is $277. You have 1 day credit that will go toward that. So it means that the court cost that will be paid, the balance is $177. You have until November 1st, 2025 to pay that. Your jail time will begin on November 1st, 2025 at or before 6 p.m.
Nothing.
You said it's 287, so it's gonna be 187. Okay. And you'll be able to pay the 187.
They'll give you credit.
Okay. All right. So, Mr. Conley, do you understand the state's offer?
Yes, sir.
You think the state's offer in your case is fair and just? Do you accept the state's offer? Mr. Conley, I'll follow a plea bargain agreement that you have entered into with the state. Mr. Conley, please stand next to the bailiff, follow her directions. Once you finish following her directions, you'll be free to go and you have a blessed day. Okay. Okay, so we have Jeshania Berry. Barrett, you can have a seat next to your attorney. Send which one to you?
Yeah. Wherever we said you can see what happens on the other.
Okay, just send it to you?
Yes, sir.
Okay. This is cause number 23 CCCR 2461, case of style of state of Texas versus Jeshania Ray Berry. Okay, state, you ready to go on this case? You announced ready earlier?
We discussed it with the defense, and there's a new offense that may have impact on this one that we've agreed to a continuance on this matter.
He got another DWI about a year ago. It's not filed yet, so I was gonna wait till we get filed. This can resolve both at the same time. You received another DWI in November 2024.
A year later from the first.
A year later from the first. This one here today is 2 years old, and the one
Yeah,
is a year old. So if they could get that one filed, I could put it on the plea docket.
When- okay.
I don't know if they're gonna get
Do we know the status of that case?
No, Your Honor. I'll look into it as best and see what I can get with Mr. Kimler
But
and see if we can do a standard reset. I'll have an answer for him for that, and we can know what to do on that date.
you could leave this one on the trial docket, but I anticipate it being a plea once the other one's filed.
Yes.
If it gets, maybe there's a problem with it. I don't know.
Yeah, I don't know. Yes, that's what I was wondering. That's why I was wondering the status. They may or may not file it.
It's not showing refused. So it's showing if you received it. Have y'all received it? It should have been received, but even with the drug test.
Yeah.
It's been too long.
So Ms. Simmons, you'll be up.
He-
Appearance in February of 26 next door.
So we need to get it transferred over here.
Yeah. You're gonna sit on the back row, huh? Okay.
And Escobar, number one. Two. Three.
Seth Savon, you're gonna go to that first row, right here, not all the way to the end. All the way, keep walking, yeah, all the way to the end, and Mr. Underhill is behind, next to him. Mr. Smith is next to Mr. Underhill. Yeah, just have a seat in the first chair.
Hamilton. Number five.
Jacob Agbar, you're gonna sit next to Mr. Smith.
Weber.
Ms. Hamilton, you're gonna sit next to Mr. Agbar. Ms. Weber, you're gonna sit next to Ms. Hamilton.
Crow.
Ms. Triplett, you're gonna sit next to Ms. Weber. Say Bell is missing.
Clark.
That's, is that Cottrell?
Yes, sir.
So you're gonna sit on this first row next to that seat that has the paper. Right there, you're gonna sit right there. Clark, you're gonna sit next to Mr. Cottrell.
Lawrence.
Ms. Pope, you're gonna sit next to Mr. Clark. Right there. Yes. Ms. Lawrence, you're gonna sit next to Ms. Pope.
Freeman. 14.
Ms. Eaglin, you're gonna sit next to Ms. Lawrence. Next to Ms. Lawrence, and then Ms. Freeman gonna sit next to Ms. Eaglin.
William.
As Mr. Cash,
Yes.
you're gonna go to the second row, right here, and then go all the way to the end behind Mr. Esclavon. And Ms. Williams, you're gonna sit next to Mr. Cash, follow Mr. Cash. Ms. Morgan, please follow Ms. Williams. And sit. Mr. Shipman, you're gonna sit next to Ms. Morgan. Ms. Ramirez, you're gonna sit next to Mr. Shipman. Ms. Duplashan, Mr. Duplashan, you're gonna sit next to Ms. Ramirez. Okay. State, are you ready? Defense, are you ready? Okay. Good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. You have been asked to come to court today to serve as a juror in a criminal case. The criminal case is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. Your felony cases are normally referred to as your most serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. Does not mean that they're not serious. It just means that they're not as serious as a felony case. Now, misdemeanors are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Now, Class C misdemeanors are cases that normally start in the city court or the JP court. They come to this court when the person appeals the case to come to this court and they get a whole new trial. And so with a Class C misdemeanor, the range of punishment is by fine only. In essence, you cannot be given any jail time. the person could be given a fine. The fine cannot exceed $500. Class B misdemeanors, the range of punishment is minimum 0 days to a maximum of 180 days, or you could be given a fine that does not exceed $2,000, or you could be given both such fine and confinement. The Class A misdemeanor range of punishment is minimum 0 days to a maximum of 365 days in the county jail, a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, you have been asked to come to court today to serve as a juror in a criminal case, which is a Class C misdemeanor. You are performing a significant service which only free people can perform. This case will be tried expeditiously, consistent with justice, which require a careful and impartial and correct trial. If selected as a juror today, you will be permitted to separate yourselves at recess, for meals, and at night. Now, before I go any further, I must administer to you the first of 2 administrative duties. That is, I have to administer to each one of you an oath. And I need each one of you to raise your right hand. And once I finish administering the oath, please say, I do. Okay, everyone, please raise your right hand. Okay. Do you and each of you do solemnly swear or affirm that you will make true answers to such questions that may be propounded to you by the court or under its direction, touching your service and qualification as a juror, so help you God? You may say I do. Okay, you may put your hands down. Now, the law requires that each of you must possess certain qualifications before you may be considered for service as a jury. There are some excuses or certain excuses or exemptions some of you may wish to claim. First, I would like to determine if you have or that you meet the qualifications to serve as a juror in this criminal case. It is very important that you answer these questions truthfully. Now, if you do not, and the lawyers or I discover this fact after you were seated as a juror on the case, you may be held in contempt of court. Now, if you're held in contempt of court, what that basically means is, 1, the case will be retried, and 2, you could be sentenced to up to 6 months in jail. You could be given a fine, and you could be given a fine up to $500. Now, the first thing I'm going to do is see if you meet the qualifications to serve as a juror. Now, I will ask a series of questions. I do not want you to answer these questions out aloud. Just please answer the question to yourself. And when I finish asking the last question, I would say, is anyone disqualified under the law? If you think that you may be disqualified under the law based on the answers that you gave to one or more of the questions, then I would ask that you raise your hand. We will have you to come up before the bench. You'll stand on this side of the bench, and then we'll discuss the matter more privately. Now, when I use the term more privately, what I'm talking about is, now we're currently airing on YouTube. We'll turn the YouTube off. We'll turn on, I have a noise device here that sounds like this. And also I would turn off the microphone. And then we'll discuss the matter more privately. Okay, so again, I will ask a series of questions. I do not want you to answer these questions out aloud. Just answer it to yourself. And then when I ask the last question, I will then ask, is anyone disqualified under the law? If you think that you may be disqualified under the law, I'll ask that you raise your right hand, and then we'll call you up one at a time to discuss the matter more privately. Now, the first question is, except for failure to register Are you a qualified voter in Jefferson County and the state of Texas under the Constitution and laws of the state of Texas? Have you ever been convicted of theft or any felony? Are you under indictment or legal accusation or on deferred adjudication for theft or any felony? Now, this next question, I'm required to ask this question by law. I'm not trying to pry into your personal affairs. We are obligated to ask the questions that I'm asking. Now, this next question is as follows. Are you presently insane or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of Texas and a resident of Jefferson County? Are you of sound mind and good moral character? Are you able to read and write the English language? Have you served as a petit juror for 6 days in the preceding 3 months in a county court or 6 days in the preceding 6 months in a district court? And that was the last question. Now, is anyone disqualified under the law? If you think that you may be disqualified under the law, please raise your right hand. Let the record reflect that no one on the panel raised their right hand. So at this time, everyone on the panel at this point are qualified. Now I would determine if anyone who is otherwise qualified to serve as a juror wishes to claim one of the following exemptions. You may claim any of the following exemptions if you choose to, but you are not required. If one of these applies to you, but you still desire to be considered as a juror, just please continue to remain seated. Okay, now I will ask these questions in the same manner that I asked the previous question. I was asked a series of questions. I do not want you to answer out aloud, just answer them to yourself. And once I finished asking the last question, I was asked, is there anyone on the panel who would like to claim an exemption? And if you would like to claim an exemption, just please raise your right hand, and then we will have you to come up before the bench. Okay, first question. Are you over 75 years of age? Do you have legal custody of a child or children under the age of 12 years, and jury service would necessitate leaving the child or children without adequate supervision? Are you a student in a public or private secondary school? Are you enrolled and in actual attendance at an institution of higher education? Are you an officer or an employee of the Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a petit juror in Jefferson County during the past 3 years? Are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? And this is the last question. Are you a member of the United States military forces serving on active duty and deployed to a location away from Jefferson County? Is there anyone on the panel who would like to claim an exemption? Let the record reflect that no one on the panel raised their hand, and so at this point, no one is claiming an exemption. Now I'll move to excuses. With the excuses, I'm not going to ask a series of questions. I will make 3 statements. And if any of these statements apply to you and you would like to claim an excuse, just please raise your right hand and we would ask that you would come up before the bench. The first statement, a juror may be excused for observance of a religious holiday upon completing an affidavit as required by the Texas Code of Criminal Procedure, Article 29.012C. A juror may not be excused for economic reasons without the consent of the parties, that is, without the consent of the defense and the consent of the state. Last statement. A juror who without prompting articulates an inability to listen to testimony and be fair and impartial may be excused. Is there anyone on the panel who would like to claim an excuse? Let the record reflect that no one raised their hand. So at this point, all the members of the jury are qualified. All the members of the jury, no one on the jury has claimed an exemption and no one has claimed an excuse. So let the record reflect that the time now is 3:19 p.m. on today's date of October 13, 2025. The court is in session in cause number 24 CCCR 0876, case of style of the state of Texas versus Jeremy Lee Ford. Let the record reflect that the defendant, Mr. Ford, is present in court with his attorney Wright Kimbler. State is present and represented by Assistant Criminal District Attorneys, Attorney Haley Simmons, and Attorney Shane Hilton. Our court reporter today is Miss Ada Christie. Miss Christie is sitting to my left. She will be taking down everything being said, so speak up when you're answering or asking questions. The bailiff in our case is Miss Brenda Mosby. Miss Mosby met you all earlier. The defendants in this case stands charged with a Class C misdemeanor of noise, violation of a noise ordinance. The state and the defendant through their attorneys have the right to direct questions to each of you concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not meddling into your personal affairs, but are trying to select fair and impartial jurors to hear and decide this particular case. If at any time you would prefer not to answer certain questions in the presence of the panel, just say so, and I will ask you to come up before the bench so that we may discuss the matter more privately. Is the state ready to proceed?
Thanks, Rodiger.
Is the defendant ready to proceed?
We're ready, Your Honor. We also filed our written notice of electing to go to the jury and evaluation
Okay, so, that you filed it pre-trial, so, okay,
or pre-board argument.
pre-board, okay. Now, Ms. Simmons,
Yes, Your Honor.
and Mr. Kimbler, so 30 minutes enough for each side?
Be a lot quicker.
That's sufficient, Your Honor.
Okay, and I will be keeping the time on this case. Okay, Ms. Simmons, you may proceed.
Thank you, Your Honor.
You're welcome.
Good afternoon. I'm excited to be here. Just show of hands, is anybody excited to be here? Honestly, great. We got 4, your number, what's your number? 7. Is it 13? Okay. Well, thank y'all for your honesty, everybody else. I'm gonna try to make it a little bit entertaining. I know we kept y'all out there for quite a while, and for that I apologize. And with that, I promise to make this fairly quick. My name is Haley Simmons. I'm Assistant Criminal District Attorney with Jefferson County. Does anybody know myself? Nobody looks familiar here. If I'm misrecognizing you, I'm sorry. Does anybody know my co-counsel here and colleague Shane Hilton? Defense Attorney Wright Kimbler? We got a show of hand on juror number 2. Let me ask you this. I was looking through y'all's panel, and you are a deputy sheriff, is that right?
Yes, ma'am.
Is that why you know Mr. Red Kimler?
Well, the sheriff's office.
Okay, how do you know Mr. Kimler?
He's been attorney on several cases.
Would that affect your ability to be impartial or? Anybody else know anybody left here? What about the defendant, Mr. Jeremy Ford? Anybody know Judge Holmes? All right, we're good to go. So how many of y'all heard what he was charged with? We have a noise violation. We're here under the Groves City Ordinance, under noise interfering with enjoyment of property or public peace and comfort. Just an idea. Juror number one, what do you think that means?
Making too much noise.
Causing a ruckus?
Huh?
Causing a ruckus, maybe?
Yes.
Okay. Can anybody give me an example of what would constitute making too much noise in the city? Don't all raise your hand at once.
Engine being too loud on your car,
Okay, engine being too loud is juror number
heating.
18. We got to speak up for our lovely court reporter back here. She gets mad if volunteers ask, so we got to speak up too. Juror number 13, you're excited to be here. What else might constitute something being too loud?
It's outside enjoying themselves, playing music a little too loud.
Okay, so outside enjoying yourself. Now, I'm gonna read the ordinance out loud. Normally I have PowerPoints up here. We run into a little technical difficulties, so I will slow down and I will say it loud. What this ordinance says is no person shall hereafter make or cause to be made any loud and raucous noise in the city, which is offensive to the ordinary sensibilities of the inhabitants of the city, which noise renders the enjoyment of life or property uncomfortable or interferes with public peace and comfort. Those two things you listed, juror number 18 and juror number 13, would you find those things to be offensive?
At midnight.
At midnight? Okay. What about you? Depends on the time of day? Okay. Let's say it's 3 o'clock in the afternoon, someone's revving their engine, is that gonna bother you?
Not really.
Just normal day city ruckus, right?
Yes.
Okay. Juror number 20. What about you? 3 in the afternoon, someone's revving?
No.
Not gonna bother? Okay, let's change it up a little bit. At night, you're tired, you're sleeping, maybe you got a newborn baby. Someone's revving that engine really loud. Juror number 9,
I've been there, done that.
been there, done that? Is that gonna bother you?
Oh, yeah.
You gonna find it a little bit offensive?
All more than offensive.
Okay, show of hands who here agrees.
With what?
What he just said. Midnight, you got a newborn baby in the house, they're revving that engine, are you annoyed? Not really? Maybe, juror number 4. Juror number 17.
17. Loud music.
Loud music. So we all understand what might be offensive to, let's say, the inhabitants of the city, aka you guys. Just trying to sleep at night. So we've got those examples. Is that interfering with their public peace and comfort? So you kind of see what the state has to prove. So we're gonna move past that. What would you like to see in this type of trial to determine if a defendant is guilty or not? What do you want to see? You want me to just say, hey, he did it, be done?
Evidence,
Evidence, what type of evidence?
video,
Okay, body worn camera, everybody wanna see that? Maybe some type of dash cam? Y'all wanna see somebody come up here and testify? So, now, when somebody comes up and testifies, they're gonna come up right here. Our questions per se are not evidence, but their answers are. So that's what you'll hear, you wanna see the evidence, you wanna hear the evidence. Has anybody heard the term reasonable doubt? Everybody? Okay. So Texas law requires me to prove my case beyond a reasonable doubt. It doesn't allow me to give you a definition. Who here thinks I should be able to give you a definition of reasonable doubt? Nobody? Good, I can't. It's not beyond all doubt. This isn't CSI, so it's not beyond a shadow of a doubt. Go ahead and tuck those TV shows away. Okay? This is the real court, so we gotta kind of get away from that. And it's not beyond an unreasonable doubt. It's real simple, guys. Unfortunately, this is the best I can do. You will know it when you see it. So whenever y'all came in and y'all had to empty your pockets and put your cell phones down, everybody had to do that? Had to go through security? Did anybody check their common sense? Did y'all bring it with you here? Good. That's all we're asking you to do. So everything we went over just now in terms of the city ordinance, you'll be able to know and determine whether I met my burden beyond a reasonable doubt. So, who here has the burden?
Yep.
Who said that? Juror number 4, absolutely right. Does he have any burden at all? It rests with me entirely. I have to prove my case beyond a reasonable doubt. And he doesn't have to do anything at all. So with that being said, as long as I meet all those elements we talked about beyond a reasonable doubt, you must find him guilty, and if not, acquittal. Does everybody understand that the burden rests solely with the state and not with the defendant? The defendant has subpoena powers, he has the right to discovery, he has the right to trial, which is why we're here today. He has the right to any type of exculpatory evidence, he has the right to defense. Now, with that being said, he also has the right not to testify. If he chose not to testify, would anybody here hold that against him? Perfect, as you shouldn't. So with that being said, I promise I'd be really quick. Jury's duty in this is to decide the facts, apply the facts to the law. I can't get into the facts right now, but a lucky 6 of you get to come back tomorrow and hang out with us, and then we can go from there. And then you'll have to follow the law with the lovely charge that the judge is going to give you. So now that I've gone over that, does anybody feel like they cannot sit in judgment of another? Everybody's good to go? All right, tired of hearing me talk? It's okay if you are. I promise I'd be quick. Again, on behalf of the state, and again, thank you so much for your patience. We look forward to presenting this case to you if you're the lucky 6 selected. Thank you.
Mr. Kimbler, panel is yours.
How many of you knew that you can bring up to county court over here at the courthouse, cases that originate in municipal court or JP court? In other words, speeding tickets, class Cs, those types of offenses that you normally deal with in a municipal court setting. United was it? Yes, Mr. Underhill. Well, just for the benefit of the rest of the panel, what's the law on that as far as class Cs that are moved up to county
It's all
court?
real.
Well, yeah, you dispose of it at the municipal court level, whether a plea or a trial, and then appeal it to the county court. It start over. It's what's called a trial de novo. And we know the reason why we just do a do-over in county court. Because there's no record in municipal. So here we have court. So the law gives you the right to just basically say, we don't want to try this case or to deal with this case in municipal court. We want to go up to county. That's what's happened here. So that's why we have people from all over the county that will comprise the jury in this case, not just people from the particular municipality. Which if you have a right to jury trial in a municipality, then your jury pool is just going to be the people in, say, Rose, and the people from Nederland and Port Neches, or wherever the city is. That's where your jury pool is going to be from, as opposed to the whole county. Plus, the judges in municipal court. A lot of times aren't lawyers, judges in county courts are, generally speaking, lawyers, except in counties where the county judge, like Hardin County. Judge McDaniel is not a lawyer, but he's the county judge, and he has jurisdiction over trials, but also as the chief administrator of the county. So he combines the duties, say Judge Brandt here and Judge Holmes into one office. And those judges don't have to be actually licensed attorneys, but here in Jefferson County, both. Because of the size of the county, both of our county court judges are actually licensed attorneys. Whereas in municipalities, you're not necessarily licensed attorneys, as in the city of Groves, Judge Lively's not a licensed attorney. So in any case, that's kind of the background on this. This is a noise violation city ordinance. City ordinances are drafted by city councils, and or probably the attorney representing the city presented to councils passed, and with the local government code, local government authority in the state that gives the municipality certain powers to draft ordinances. Sometimes they go overboard and have ordinances that exceed the power of municipalities to draft ordinances. Generally speaking, the noise ordinances have they're, as long as they're strictly drafted and meet the constitutional requirements, have been held to be constitutional of the powers of the city. Now, in this particular case, you're gonna have, the city ordinance is gonna be contained in the complaint, which, Mr. Ford's gonna be pleading to here shortly, but it's also going to be in the charge of the court. Those of you that go back and are on the jury, when you get the case, you'll have what the ordinance is. I anticipate it's gonna be something along the lines. Sort of kind of like a two-part test. It has to be, there's an objective standard. This has to be a loud and raucous noise, right? So whatever it is, objectively speaking, you have to determine beyond reasonable doubt, this was in fact, Mr. Ford did in fact create a loud or raucous noise. Well, what is raucous? That's kind of an interesting word. I guess it's kind of like ruckus, ruckus. You create a ruckus, something is raucous. And a noun and maybe an adjective form of the word. Mr. Ms. Milan, what is a raucous noise or a ruckus? What would you think? What is that?
I would think it's just loud and maybe aggressive at some point.
Well, it has to be loud and raucous. I guess there's a difference, maybe just sort of, maybe it's just a lawyer that want to use two words instead of one, so you have loud and raucous. But is there any difference between loud and raucous?
Not to me.
Raucous doesn't really add anything to loud.
No.
Like you could have a loud noise that may not create a disturbance perhaps, and then these are inherent in the idea of a raucous, that there's some sort of disturbance potentially can create a disturbance.
Could be, but
Dr. Underhill, what do you think?
Loud, disturbing.
So raucous, you could think, they can say disturbing, but what like inherent in the idea of a raucous noise? What would a raucous noise be? An example of a raucous noise?
Like a loud stereo or like they said, loud engine or something.
Why, what makes that raucous as opposed to just loud? Oh, no, don't care. I don't know, but it is loud and raucous, that's what's required. Mr. Smith, what do you think? What's the difference between a loud noise and a raucous?
I've never heard the word raucous meaning. I'm not familiar.
Ruckus,
It's just an adjective saying how loud it is.
Well, we heard of a ruckus, like he's creating a ruckus, there's a ruckus.
Okay, I understand.
Yeah, I guess raucous is this the
I
adjective
understand what you're
ruckus.
saying.
What is raucous? How does that add to loud?
Maybe something annoying to somebody that just don't stop.
Well, something more than loud, right?
Yeah.
You gotta be, because you got
More than that to annoy somebody to the point where it gets where it annoys. Them.
yelling and screaming, right? Maybe that's a raucous, it's loud and disturbing. Example, Mr. Agmore, is that right? What do you think? What's raucous add to loud? Anything?
Color, just like an F-bomb.
Okay. Disturbance, potential disturbing the peace, maybe breaking the peace kind of thing.
Same difference.
Ms. Hamilton, what do you think?
Maybe irritating noise,
So some loud noises might not be irritating,
like screeching or something,
like a person screeching or screaming.
or. You know, some device screeching.
Can you think of an example, like a car engine or
Some kind of high pitched. Scraping or, you know, more like a construction noise, I guess.
okay.
Just what you
What about fireworks?
I'm sure that's your.
Could that be a raucous?
I guess so.
But so fireworks are supposed to be a raucous noise?
I guess to some. Mhm.
Well. And then it has to be offensive, that's the other part. Do you think the sound of fireworks exploding to me or is it that is offensive? Should be a raucous, has to be a raucous noise to start with. So some raucous noises aren't offensive by the statute, so it has to be loud and raucous, and then it also has to be offensive. Do the sounds of fireworks exploding offensive? Perhaps, maybe?
Perhaps.
Yeah, maybe. Okay, what do you think, Ms. Hamilton? I'm sorry, Ms. Weber. Weber? Max Weber, that's some people pronounce it Weber, but Weber.
Fireworks, for example, yeah, I think that would be intrusive for like late at night and you're trying to sleep and you have dogs, you have babies, etc.
Very
Like, you have
raucous.
PTSD,
Yeah.
stuff
PTSD.
like that's a lot.
But people go to see fireworks all the time, publicly displayed by the city. Right,
Except at night.
so what would it depend on? So we know in some circumstances. Because obviously, fireworks are okay because they're made by the city authorities themselves, right? So what would change where fireworks should be loud and raucous in your opinion, and offensive?
I think it's more so like the time and regulation, like you were prepared that fireworks 7 to 9, okay, I know that's what time that's gonna happen, you can make adjustments in your home, et cetera, for yourself, to make sure that's not a
Would you expect that that kind of limitation would be contained in the ordinance itself, relating that there would be a particular ordinance relating to fireworks?
maybe.
Do you think municipalities have ordinances that relate to the detonation of fireworks within the city limits? So if somebody were charged, or there's something amiss or illegal or problematic with somebody detonating fireworks in the city limits, you would expect a specific charge related to unlawful detonation of fireworks in the municipality, right? This, triplet, what do you think? What's a raucous, with the raucous noise?
Agree with them, disturbing, annoying, loud and disturbing. And I guess it depends on the person, their perception of it and what they're doing at the time.
Well, this has to be objectively loud or not. It's not a subjective standard. You have to say it objectively, not just to me because of PTSD or whatever. Because it's specifically objectively, this is loud and raucous, right? So we could agree perhaps that fireworks are loud and raucous, right? Maybe, but they're not offensive because the city does. So that's to also be offensive. So that's maybe more of a subjective idea, right? Could you see what, so there you can envision a loud and raucous noise that may not be offensive. What would be the offending, what would constitute the offending nature of a loud and raucous noise in your opinion?
Things like a baby sleeping or your dogs are terrified of fireworks. I think that kind of makes it offensive to me.
What about the time? Time. Would you expect the state, as far as approving offensiveness, that they would have to have somebody, a citizen come in to testify that they were offended? So to establish, you would expect that? Right. To establish that it actually was offensive. What about you, Mr. Contra?
Cultural.
Contra.
I think it'll have to be prolonged.
Okay, extended.
Yeah, you're not gonna talk to somebody for slamming the car door at 10 o'clock. Once. We're going to every 10 minutes for the next 2 hours, then yeah, it's a problem.
Not, you use an example, slamming a car door,
Anything that makes a loud,
raucous.
raucous noise, and it's gotta be, like I said, prolonged.
Okay, so the length,
Repetition.
duration, that's a good point. I can go back to what I was saying there, they said loud, the ordinance itself says loud and raucous, what you said, loud and raucous, does raucous add anything to loud?
Not so much.
Not so much. Could you conceive of a loud noise that wasn't raucous?
No, that's why I should make sure wear earplugs.
Yeah. Okay. What city do you live in? Or do you live in county or the city?
County.
County. So there's no ordinance with fireworks or anything out there, a lot of no ordinances really other than your county stuff, right? Why did you choose to live in the county versus say in a city? Or municipality?
I grew up in the country and I don't function well in densely populated areas.
With ordinances, right?
Not so much ordinances, it's more of a social anxiety.
Yeah. You just like to be crowded. Yeah, I mean, I live in Mobile, so I'm with you on that. And you don't have ordinances up there. So if somebody's shooting fireworks at, 2 in the morning, then that's just the way it is,
Well,
right?
if that's the case, I should be able to call you guys and complain they're running a pile driving on I-10 at 9 o'clock at night.
Oh, who, me?
Call anybody.
Me.
But I'm not, what good's it do for me to call?
Sorry?
If I call the sheriff and go, hey, I'm trying to sleep and they're running a pile driving, well, that's different because it's construction.
Right. Well, you're out in the county too, which I guess, and I would imagine, ask Mr. Hunter, what would be his resort, what would be? You're the sheriff's department. Just raise running.
We don't deal with that kind
So there's your answer. You call it, we don't do it.
but it's a legitimate question.
Right. But I guess if you live in a municipality, you have different expectations, right?
Yes,
Just like how HOAs, why would anybody ever buy a house in an HOA?
and be told. when-
Including told, another layer being told what to do. Yeah, I don't understand that either. In any case, you can be a fair and impartial juror in this case. Right, okay. Mr. Clark, what do you think? For raucous, I just stick with my raucous.
The difference between a loud noise.
Yeah, raucous.
You know. Raucous, I would think would be something that's deliberately done as opposed to an accident, not folks cans in the middle of the night waking their neighbor up, something like that.
What if I said, that guy's creating a ruckus? What would come to mind? They're creating a ruckus.
Deliberately, you know,
What's a ruckus, like a fight or confrontation, disturbance?
a disturbance and annoyance.
What would it take for that to be offensive? Something out of the ordinary? Normal, violates a normal expectation.
I mean, if it's somebody else playing their stereo at 2:30 in the morning, making their own neighbors up, then, you know.
Yeah. That's easy.
That is offensive.
Yeah. Our band practice at 2 o'clock in the morning in the garage up to your house.
Exactly.
Right, we can all agree on that one. All right. What do you think, Ms. Pope?
Probably where I used to live, some years ago, I lived across the street from, a body shop,
Mhm.
but it was, zone residential.
It was in a municipality.
Yes.
Yeah.
And it went on for a couple of nights. They were in there doing body work. After 10, it was late. I called the non-emergency number to complain.
City of Omaha?
No, I didn't. look
Oh,
at
sorry.
it. And, the lady that took the call, she thought it was not as serious as I was saying it was, and then she heard it. So I was like, but it wasn't the first time, that it happened, so it happened when
So what happened? Ultimately,
that's,
so they came out and talked to him and stuff.
yeah.
All right, and did you consider it a ruckus?
Yes, I
Rock?
did.
I mean, what
I did.
what made it a ruckus, Steve?
It was
Ruckus.
something word in my code. It was, like nails on a chalkboard. It was incessant.
That was the offensiveness, maybe, that's the nature of.
Yeah.
Something, just that grinding, grating, noise.
Yes.
That would go to the offensive element.
Yes, and it was non-stop.
And the duration.
Yes, duration.
All right, Miss Lawrence, what do you think? Lawrence? What do you think?
I would think it would be disruptive to your life. Causing her alarm to go off and they're shaking. Continuous.
How long did you say continuous? What was your idea of continuous, like duration? What was your idea of that? How long?
I mean, generally, even when someone does fireworks, fireworks expenses don't last for very long. So I would think something that's just continuing to go on for an hour or more, that it's just disruptive to your life.
You work at the McFadden Ward, director of the, I guess, education. This is kind of digressing. That house was built in the 30s.
At 1907.
I hope that's probably. I always had the idea it was built during the Depression, so it wasn't actually pre-production. He was actually not about the phase. All right, Miss Evening. Play the May one. Related to a May evening, no? We worked up here before else for a while. What do you think?
Well, I experienced a lot of, peak hours. Y'all know what I said.
Yes, ma'am.
Called the police a couple of times and I see them do it. Did I know who was playing it?
Mhm.
I didn't get any, no, I didn't. And they said it was in the officer out. No, it is in the officer out, so.
So you think if there would have been a complaint, let's say a complaint filed, like a violation, and the person contested it, do you think that the city prosecutor would have brought you in because you're the one that complained about it and say, yeah, I was offended by that? Well, you have to have somebody to say that they were offended by it to prove the case, right? it'd be you or somebody else that actually was offended that heard it, right? To establish that it was offensive. You think that that's reasonable to expect the state to do that? Like if they're saying it's an offensive noise, right? That's part of the statute. That it's reasonable to expect that they're gonna bring somebody in who was offended by the noise in the neighborhood, right? To prove.
But did they know it was him? Did they know it was that person?
Well, that's what I'm saying. Somebody say, look, I heard a noise, and I thought it was loud and raucous, and I was offended. To have somebody come in and make that complaint, right? Just like if you say you threaten somebody and you're charged with terrorist threat, the person that you made the threat, they gotta bring them in here, right?
Like the 911 call, say, do I know it was that person? Do I know who the people are playing the music?
Right. But let's say that the police can identify who the people are, they just have to have somebody testify about the noise, right? You would have to come in and say, hey, I was offended by that, right? Somebody would have to come in and say, right? What do you think, Ms. Brennan? I'm sorry, Brennan, right? Yes, ma'am. What do you think?
Most is the norm, it's lingering,
Mm-hmm.
and it's just something you don't have to do. Like, say for instance, I got somebody that comes on my driveway. And my bedroom was right there, just. So I got up and I just said, if you're gonna be on my driveway, you're not gonna run that motor.
Right.
Because it is irritating, it's disturbing, I can't get to sleep.
Offensive.
Offensive,
Right.
very offensive to people. I have one truck that comes and he don't stay long because I'm assuming he's picking up somebody for work and he goes to somebody's business. So he does that, okay. But now if you're gonna sit up there and just keep a motor running, it's loud.
That's the offensiveness
Yeah.
that is part of the stage. All right. That's good. All right, well, I'm up here kind of flogging the dead horse, I guess, but, does anybody in the back row have any comments they want to add about anything I'm talking about? On the raucousness, loudness, offensiveness, no? Why are you wasting my time with it? All right, well, it is, it is a criminal offense, right? You have a right to a jury trial, and perhaps more people, I would encourage people, that you have a right to a jury trial in municipal court on speeding. Encourage everybody, if you contest a ticket or something, to request a jury trial and you can try a case yourself, you don't need a lawyer to do that. In JP court or municipal court. Juries are, sort of a real, I guess, a real power, a real guarantee of freedom and liberty are with the jury system. I have tons of respect for the jury system, having lived in countries where they don't have juries, particularly roughly, they don't have much of a jury system. I'm a firm believer in the jury system. And you got your jury summons, you came in here, you showed up, thinking, well, geez, I'm gonna sit on a jury where it's like a murder or robbery or something important, and you show up, and it's like, a court's violation from the city of Groves. I think it's kind of anticlimactic, but it's still you're fulfilling an important function in the system, even on a case, a class C appeal. So I thank God for that.
Okay. Okay, ladies and gentlemen of the panel, at this time, I'm gonna ask that you go out into the hallway. And we may call some of you back in for some follow-up questions. So at this time, everyone please stand as the panel exits the courtroom. You can go out either door, both doors open. Okay. Court will be in recess.
Good morning.
No, it's fine. What did you already say? Could you say how time and stage?
Should we?
I believe that's where.
Oh, let me sign.
Okay. Jefferson County Court at Law number 2 is back in session. The court is in session and calls number 24 CCCR 0876. Let the record reflect that the panel is now present in the courtroom. Let the record also reflect that the defendant, Mr. Jeremy Ford, is present in court with his attorney, Attorney Wright Kimler. Let the record also reflect that the state is present with Assistant Criminal District Attorneys, Attorney Haley Simmons and Attorney Shane Hilton. At this time, ladies and gentlemen of the jury, we have Ms. Trina Redmond. She's going to call some names. If your name is called, please go to the jury box. There are some tags on the top counter. You can take a tag and pin it on your clothing. At this time, Ms. Redmond, the panel is in your hands.
Edward Latrell Esclavon,
Esclavon, okay.
Paul Douglas Smith,
Anywhere, sorry.
Christine Hamilton, Clayton Donald Cottrell, Paul Anthony Clark, Jennifer Lynn Lawrence, Robert George Cash.
Yes, sir. Did you know that? I mean,
You can pin those badges on right now. Okay, members of the jury. Okay, members of the jury, at this time, I must administer to you the second of the two oaths that I had previously mentioned. At this time, I need every one of you to raise your right hand. And then when I finish administering the oath, please say, I do. Do you and each of you do solemnly swear that in the case of the state of Texas versus Jeremy Lee Ford, you will a true verdict render according to the law and the evidence, so help you God? Please say I do. Okay, you may put your hands down. Members of the jury, I will give you some instructions and a general idea of what to expect in this case. Every case is composed of the facts and the law as it applies to the particular case. The facts come from the witnesses on the witness stand. The law comes from the statutes, codes, rules, and other court decisions interpreting them and how they may apply to this case. You and I have equal authority, but it is divided authority. You are the sole judges of the facts, and I'm the sole judge of the law. You are the sole judges of the credibility of the witnesses and the way to be given their testimony. You can believe all of what a witness says, part of what a witness says, or none of what a witness says. As the trial progresses, the attorneys will probably make objections to questions asked by the other attorney of witnesses or objections to the introduction of documents or objects. This means that in the objecting attorney's opinion, there is a legal reason why the testimony, a document, or object should not be received by you. Sometimes I will simply sustain or overrule the objection. At other times, it may require a lengthy discussion outside of your presence. If that happens, I will either ask you to step outside for a few minutes or ask the attorneys to come up to the bench so that you can hear the discussion on the point of law. The reason for this, as I told you earlier, you're the sole judges of the facts you receive, and I'm the sole judge of the law. I can't be with you in the jury room when you deliberate the facts. Therefore, you can't be present or within hearing when I deliberate questions of the law. The reason why I will sometimes ask you to step outside is because it is simply the most efficient way to do it. Otherwise, if we were to leave the courtroom, the court reporter would have to gather her equipment and take it with her. The attorneys would have to gather their files, etc. The ruling I do make on questions of law in your presence are not evidence, and you are to disregard them. After all the evidence is in, and both the state and the defendant have rested their cases, the court will prepare for you a charge, instructing you on the law in this case. You will then hear oral arguments from both sides. You'll hear oral arguments from the defendant, and you will hear oral arguments from the state. The attorneys have the right to make a summation of the evidence and make reasonable deductions from the evidence. Since the state has a burden of proof, it has the right to open and close the summation or argument. Until you retire to deliberate, do not discuss this case amongst yourselves, and under no circumstances should you permit anyone to discuss the case with you. Do not attempt to learn from any source outside of the courtroom anything about this case, nor attempt any independent investigation on your own. Don't visit the scene involved in the facts of the case. Don't read any reports in the newspaper or watch television reports about the case, or even anything that may be on social media. Do not make up your mind about this case until all the evidence is in and you have been instructed on the law. Don't take notes during the progress of the trial. Don't visit other courts during a break if a trial or other proceeding is in progress. The badges that you have, you will be allowed to take those badges home. Please wear those badges when you come to the courthouse, because those badges identify you as a juror in this case. Now, ladies and gentlemen on the panel, those of you who were not selected to serve as a juror in this case, I know some of you are somewhat disappointed because you had expectations of serving as a juror in this case. But the way the law is, we only can have a limited number of people to serve as jurors. I know sometimes when people come, and they don't get selected, they might think that, I came here, stayed here a couple of hours, went through voir dire, didn't get selected, I wasted my time. Well, no, you did not waste your time. And the reason why I say you did not waste your time is because before you came into the courtroom, we had cases that were being disposed here in the courtroom. In essence, your presence helped cases to be moved. And so I'd like to thank you for taking time out from your busy schedules to be here this afternoon. I know that when you came to court today, you probably looked over the door of the courthouse or of the courtroom, and you probably said, "Oh, I'm in the right place. This is Judge Holmes Court, County Court at Law number 2. Well, this is not Judge Holmes Court. This is the courtroom for the citizens of Jefferson County. I'm only a humble public servant serving the citizens of Jefferson County. You are the citizens of Jefferson County, or we are the citizens of Jefferson County. And so I said that to say this. Anytime that you're in the neighborhood of County Court at Law number 2, please and come have a seat in your courtroom. You'll be allowed to sit in the area that you're sitting in. We call that the peanut gallery. But it doesn't mean you can bring peanuts in here and eat, because this is not the Texas Roadhouse. But you can come and have a seat in your courtroom and see what goes on. And I know you will find it very interesting. Now, this trial is going to start back up again tomorrow at 1:30. At that time, we will have opening statements. We would present the information. In a misdemeanor case and in Class C misdemeanor case, we have what is called a complaint. If it was a felony case, it would be called an indictment. It's just a charging instrument. And so the state will read the complaint, then the state and the defense will give an opening statement if they choose to, and then the state will put on its witnesses. In essence, the case will start. You'll be allowed to come in and have a seat in that area. We call it a peanut gallery if you choose to. If you do not have the time, you can watch us on YouTube, because we will be, all our cases and proceedings in this court airs on YouTube. Okay, so our bailiff have some letters for you from County Court at Law number 2. She'll give a letter to each and every one of you. Once you get a letter, you'll be excused. And before you leave, I usually give everyone a handshake, but we still have COVID in our community. So at this time, I will give each and every one of you what I call an air handshake. Okay? So I give each and every one of you an air handshake. Once you get your letter, you're free to go. You have a blessed day. If you need something from the district clerk's office, they're right across the hall. And every one of you have a blessed day.
Appreciate it, sir.
You're welcome. Okay, ladies and gentlemen of the jury, with this court will be in recess on this case till 1:30 on tomorrow. Okay, so we need to have you show up at 1:30. Please
Yeah.
have a seat outside in the court, well, in the lobby area or in the hall. And then our bailiff will come and get you when we're ready to start on the trial. Okay, so we'll see you tomorrow at 1:30. Everyone, please stand as the jury exit the courtroom. Okay. I guess Mr. Ford can leave. We're gonna adjourn.
Trying to cover us.
Right, don't call the record. I want to.
Jefferson County Court at Law number 2 is back in session. The court is in session in 2 cases. They are cause numbers 23 CCCR 2461 and cause number 25. Excuse me. And cause number 25 CCCR 2275. Both cases are styled the state of Texas. This thing keep coming up. Okay,
That's not.
She has to get ready for tomorrow.
Yeah.
You
Trial 3 weeks in a row now, I'm tired.
She's gotta go research for
know,
it.
she has.
Are we doing this still? This will be fun.
on a minute.
Oh, fun, right?
Everything's.
Okay, this is cause number 23 CCCR 2461, case of style of state of Texas versus Jeshunio Ray Berry. Mr. Berry, is that your full name?
Yes, sir.
Mr. Berry, would you please raise your right hand? Mr. Berry, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Berry, you may put your hand down. How are you doing, Mr. Berry?
And you?
I'm doing fine. Thanks for asking. Mr. Berry, you're represented in your case by your attorney, Robert Kimler. Mr. Kimler, do you waive a record in Mr. Berry's case?
Go away.
Mr. Berry, I have before me on my computer a document in cause number 23 CCCR 2461. This document is titled Information Sheet. This information sheet was filed by the Jefferson County District Attorney's Office. In this information sheet, Mr. Berry, it alleges that you, Jeshunio Ray Berry, on or about September 16th of 2023, while you were in Jefferson County, Texas, that you committed the class A misdemeanor offense of driving while intoxicated with alcohol concentration level of 0.15 or more. State, are you abandoning the enhancement paragraph?
That's correct, Your Honor.
Mr. Berry, the state is abandoning the enhancement paragraph in this case, and what that means is instead of being charged with a class A DWI, you'll be charged with a lesser included offense, which is a class B misdemeanor offense, DWI. Do you understand?
Yes, sir.
Now, to the class B misdemeanor offense of driving while intoxicated, which allegedly occurred on or about September 16th of 2023, while you were in Jefferson County, Texas, operating a motor vehicle in a public place. Do you plead guilty, not guilty, or no contest? Yes. Now, are you pleading guilty freely and voluntarily? Yes. And are you pleading guilty because you are guilty? Yes. Mr. Berry, I also have a document that is titled misdemeanor plea admonished, was also labeled as State's Exhibit Number 1. You recognize this document? Yes. On page 2 of this same document, you got to file that. There's a set of initials on a line next to a box that's checked guilty. Did you place your initials on this document? Yes. On the third page of the same document, there's a signature above the line that's titled defendant. Is this your signature? Yes. And on the next document that's titled trial court certification, the defendant's right of appeal, do you recognize this document? Yes. And is this your signature on the line that's titled defendant? Yes. At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Yes. The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? Yes. I also have a document that is titled discovery certification. You recognize this document? Yes, is this your signature on the line that's titled defendant? Yes, Mr. Berry, before you signed and initialed these documents, did your attorney go over these documents with you? Yes, sir. And did you understand everything that your attorney went over? Yes, sir. Is everything in these documents true and correct to the best of your knowledge? Yes, sir. Mr. Berry, are you a citizen of the United States? Yes, sir.
State over State's Exhibit 1.
Any objections?
No, good.
No objection. State's Exhibit Number 1 will be admitted. Mr. Kimmler, you have advised and counseled Mr. Berry. Is there any evidence that he is currently mentally incompetent to stand trial?
No, I'm aware.
And Mr. Berry, your attorney, Mr. Kimmler, has advised and counseled you. Are you satisfied with his representation? Yes, sir. Has he provided full, effective, and competent legal representation? Yes, sir. Mr. Berry, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is that agreement?
Your Honor, we'd ask the court for 90 days county jail, probated for a period of 18 months of community supervision, fine of $500, repayment of court costs, 24 hours of community service, requirement of the interlock device, and the standard DWI first terms and conditions of probation. And this is to run concurrent with the companion case 25 CCCR 2275.
And he doesn't currently operate a motor vehicle.
Okay. So this is gonna be CC with.
Yeah. He'll be off of probation. Get it back.
Okay, that's community service. What's the court cost?
$392.
Thanks. Okay, Mr. Barrett, the state is offering that you serve 90 days in Jefferson County Jail, but you will not have to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 18 months. During the 18-month probationary period, you'll be required to pay a fine of $500 plus court costs of $392. You'll be required to pay a DWI conviction fine fee of $100. You'll be required to pay a probation fee of $6 a month. You're not $15 a month reimbursement fee of $15. You'll also be required to pay Jefferson County DWI education and initial evaluation fee of $125 on the day of the police. Should a further evaluation be needed, you'll be required to pay an additional $50. Your total monthly installments, that is the total amount that you will be required to pay in this case, is $139 a month. Will you be able to pay the $139 each month?
Yes.
You'll also be required to install the interlock device on any vehicle that you own or operate. You're required to attend and complete a DW education class, have an alcohol assessment, and adhere to the other standard terms and condition of probation. This case will also run concurrent with cause number 25 CCCR 2275. And Mr. Barrett, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in this case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Barrett, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Barrett, we will move on to your next case. And your next case is cause number 25 CCCR 2275. And in this case, Mr. Barry, I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Jushenio Ray Berry, on or about November 23rd of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense to drive while intoxicated with an alcohol concentration level
You're dropping.
of 0.15 or more, and state, are you abandoning the enhancement paragraph?
That's
This
correct.
case? Okay, Mr. Barrett, the state is abandoning the enhancement paragraph in this case, and as I mentioned to you earlier, instead of being charged with a Class A misdemeanor in this case, you'll be charged with a Class B misdemeanor DWI. Do you understand what you've been charged with?
Yes, sir.
And two, the Class B misdemeanor offense of driving while intoxicated with an alcohol concentration level. To the Class B misdemeanor offense of driving while intoxicated, which allegedly occurred on or about November 23rd of 2024, while you were in Jefferson County, Texas. How do you plead guilty? Not guilty and no contest.
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
Mr. Barry also have a document that is titled Misdemeanor Plea Admonishments. This document is also labeled as State's Exhibit number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a set of initials, JB, on the line next to the boxes. Check guilty. Did you place your initials on this document?
Yes, sir.
On page 3 of the same document, there's a signature above the line that is titled Defendant, is this your signature?
Yes, sir.
On the next document, that's titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to appeal. You understand that statement?
Yes, sir.
I also have a document that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Mr. Barry, before you signed and initialed these documents, did your attorney go over these documents with you?
Yes, sir.
And did you understand everything that your attorney went over?
Yes, sir.
And is everything in these documents true and correct
Yes,
to the best of your knowledge? State, you like to offer states 1?
Yes, Your Honor.
No objection. States Exhibit number 1 will be admitted. And Mr. Barry, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I'll also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement in this case?
Yes, we do, Your Honor.
And what is that agreement?
Your Honor, it'd be 90 days county jail, probated for a period of 18 months of community supervision, a $500 fine, repayment of court costs, 24 hours of community service, the interlock requirement, and the standard terms and conditions of the DWI first, and that it run concurrent with the companion case 23 CCCR 2461.
CC with 2, 3, 6, 2, 6. These $500. Okay, that's 100. What's the court cost in this case? 392. Everything else is gonna be waived. 2, 3.
A day, I believe.
Okay, yes. Huh? Yeah, it is it's 0. Okay. Now, Mr. Barry, the state is offering that you serve 90 days in Jefferson County Jail, but you would not be required to serve any time in the Jefferson County Jail in this case, because you'll be placed on probation for a period of 18 months. During the 18-month probationary period, you'll be required to pay a fine of $500 plus court costs of $392. You'll be required to pay a DWI conviction fine fee of $100. You will not be required to pay a probation fee in this case because you paid it in the other case. You will not be required to pay your analysis fee in this case because you paid it in the other case. And you will be required, that'll be 3. You will be required to pay a $15 reimbursement fee. Your total monthly installments, that is the total amount that you will be required to pay each month while you're on probation, is $59 a month in this case. Will you be able to pay the $59 each month?
Yes, sir.
Now, you also be required, I guess you paid that one DWI education and fee in the last case, so you probably won't be able to pay it in this case. You will be required to install an interlock device, like in other, it's just running concurrent.
Yes.
And you will be required to have an alcohol assessment. In this case, will run concurrent with your previous case, cause number 23 CCCR 2461. You will also be required to perform 24 hours of community service
Yes, sir.
in each one of these cases. Now, Mr. Beer, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay, I'll follow the plea bargaining agreements that you have entered into with the state. Mr. Berry, you can stand at the end of that table, follow the directions of the bailiff. Once you finish following the directions of the bailiff, you can follow the bailiff. You have a blessed day. And Mr. Kimmler?
The hearing I've got in Hardin County is at 1 o'clock. I've got confirmation at pre-trial. So
Ooh.
you could, I mean, it's whatever you and Judge Thomas.
Yeah, I may have to give him a call in the
I
morning.
do need to be up.
Okay, I thought it was in the morning. Okay, I may have to give him a call in the morning.
But it's pretty important.
Okay, we'll give him a call. All right. Okay, so this will conclude the calling of the jury trial docket this afternoon in County Court at Law Number 2, Jefferson County, Texas, on today's date, December 13th, 2025. Judge Terrence Holmes presiding. Prosecutors, you are excused, and Mr. Kimmler, you're also excused. Y'all have a blessed day. You're welcome. Everyone, please have a blessed day.